Hi, this is Jack Razumich with Razumich and Delamater. Today I'd like to speak with you about a concept in the law called constructive possession. Before I do that, if you have any questions about this video or any other topics of the law that we haven't covered, click the link below to be taken to a page where you can schedule a free case evaluation and get additional information about your case. Setting the case evaluation is free, as is talking to us, and we're happy to speak with you. So what is constructive possession? Well, this case comes up in drug and firearms cases on a regular basis. It's not uncommon for a person who's in a car or a house or an apartment, when it gets stopped or raided by the police and they find drugs or guns, and everybody in the house or car gets arrested and charged with possession of the offense. The idea is that everyone in that house or car or what have you had the equal ability to possess the item, and therefore they could be guilty of that possession. Now, possession is a legal term, like many things in law. Are. Possession means the ability to exercise dominion and control over an item. Exercising dominion and control over an item means that you're aware that the item exists, you're okay with the item being near you, and you have some sort of ability to actually say what does or doesn't happen to that item. An example that I usually use with my clients is when they come to my office, I'll have a stapler on my desk. They can probably see the stapler's there. They probably don't have an issue with the stapler being there, but they can't actually decide what to do with that stapler, so they don't have any possession over it. Now, in a constructive possession case, that gets proved by what's known as circumstantial evidence. Circumstantial evidence is evidence that would allow for a jury to create an inference that this is a true fact. Things that they look at with regards to constructive possession cases are, where is the item found in relation to the person that's being charged? For example, if the item is found underneath their particular seat in a car, that's probably bad. If the item is found in the trunk of somebody else's car, by which I mean if you're riding in somebody else's car, the car gets searched and they find a gun in the trunk, but it's not your gun, it's not your car, that's a little bit better of a situation for the defense. In house raids, if they find some drugs in a room that clearly has nothing but your stuff in it, or if they find it in a drawer that has nothing but your papers in them, that's referred to as commingling. It can be a little bit stronger of a concept that, yes, even if you're not there to physically possess an item in person, you might have the constructive possession on it. Now, constructive possession cases are hard for both sides. From the state perspective, juries usually like to see that people are actually in physical control over something they're supposed to be possessing. Most times, as I said, this is proved by circumstantial evidence as opposed to direct evidence of possession. On the defense side, it can also be very difficult because you have to explain a lot of coincidences to the satisfaction of the jury. Again, if you're in a car, your car happens to be titled in your name, the drugs happen to be found under your seat, it might be a little bit difficult to argue that they don't belong to you. Constructive possession cases, because of their difficulty, require good, competent attorneys who have experience handling them. Our office has helped several people in the constructive possession cases, and I'm positive we can help you as well. We look forward to that opportunity. Remember, if you have any questions about this video or anything else, click the link below. We look forward to helping you.